SJC-12473, Donna Kelly Williams and others, v. Attorney General and another.
Mr. Colbert, good morning.
Good morning, Mr. Chief Justice, Justices of the Court, may it please the Court. I'm Ed Colbert for the petitioners, and I'm here with my colleagues David Koha and Carmen Francella. The issue in this case is whether, in light of well-established principle that initiative petitions are to be construed in order to support the people's prerogative to initiate and adopt laws, the common purpose of this patient safety petition contains sufficiently related subjects under Article 48. We maintain that the petition meets the standards set forth by this court in the Mass Teachers Association case in 1981, being the common purpose test, including a later inquiry that the court developed in 2006, which asks whether subjects of a petition are operationally related such that they present the voters with a unified statement of public policy. The common purpose of this petition is patient safety. The subjects used to achieve this common purpose are patient assignment limits, transparency in staffing, and hospitals' financial resources and enforcement. There can be no doubt that hospital assets are not only related to, but are critical to nurse staffing. The briefs in this case, as well as the companion Oberle's case, make that very clear. Opponents of this petition and the petition in Oberle's claim that nursing staff or increases in nursing staff that would be required by these initiatives would be cost prohibitive. Conversely,
so you're asking, your provision calls for all financial assets. And what would that include?
Specifically, that would include the revenues of the hospital, the assets in the form of tangible assets, all assets that would be listed on a typical financial statement, balance sheet, income statement. Interestingly, much, if not all, of the information that would be required by this particular section on financial assets arguably is already required under the Mass General laws. There's a dispute ongoing about this particular subject, which is being litigated in the Superior Court, but the reason that it's contained within this petition is because of the connection between cost and assets that are available to pay for nurse staffing and the nurse staffing requirements that will be required by the other provisions of the petition.
But you're asking for financial assets in a very broad sense, not in terms of financial assets that might relate to patient-nurse ratios.
That's correct, because the petition, we feel, is broader than simply patient-nurse ratios. It is patient safety is what we feel the common purpose and design of the petition is. And as part of the goal of achieving patient safety, one of the subjects is patient assignment limits on individual nurses. The other subjects are transparency in the way that those staffing levels are reported to the agency that regulates it, as well as to the public, and the resources that are available to provide that staffing. The criticism for nurse staffing, as I had alluded to earlier, is that there aren't enough resources available to achieve greater nurse staffing ratios, and that's the objective and the purpose of this petition, is to achieve greater nurse staffing limits. And the reason for the transparency provisions, which would disclose not only the staffing that hospitals are providing, but also the means to do that staffing, is so that agencies and the public can make an assessment as to whether individual hospitals are providing levels of staffing that are consistent with patient safety.
So relatedness and mutually dependent, the argument is see the sky's not falling down if we do this.
The sky certainly isn't falling down if we do this. The two subjects in the petition with regard to nurse staffing is really an expansion upon existing law. Chapter 111, Section 231 contains a patient limit on the number of patients that could be assigned to nurses in intensive care units. That's the law today. This would expand patient assignment limits to other units of hospitals.
Is there any requirement in that statute with regard to the ICU that hospitals or care facilities or whatever they are provide their financial information?
Not in the particular statute, no, there aren't. There is, however, as I alluded to earlier, there is in Chapter 12C of the Mass General Laws a requirement that hospitals disclose all of their finances. And
who are they supposed to disclose those to?
those are disclosed to the Center for Health Information and Analysis, CHIA, it's better known as, which then turns around and discloses hospital information to the public via its website. That agency has been in place since 2012 and contains a wealth of data on hospitals already.
So my question may not be directly related to whether this is a valid exercise of the initiative petition, but isn't the information already available?
The information should all be available, but it is not available because, among other reasons, there is one particular hospital group in Massachusetts, Steward, which has contested, challenged, I should say, the agency's right to insist upon the financial data that it is insisting upon. The Attorney General is representing CHIA in a lawsuit that Steward filed last fall in Suffolk Superior with regard to the reach of CHIA's statutory authority to insist upon financial data that relates to, in that particular example, parent organizations and out-of-state hospitals.
So I just want to make sure I understand the principle. So this nurses provision is going to raise hospital costs, right? They're going to need to hire more nurses. So anything related to financial data, then, you're entitled to every piece of financial data regarding the hospital that's related and mutually dependent. I'm just trying to understand the principle. There's no over-breath requirement.
In terms of the standard, I would suggest that the standard of relatedness or mutual dependence requires that a petition have related subjects or that they
I
be
understand the
mutually
legal,
dependent.
I'm just trying to understand the principle from your perspective. Everything to do with the hospital's finances is related and mutually dependent then?
Hospital finances would be related to whether or not a hospital is, through its staffing, providing safety for its patients.
So every salary should be public to you, should be available. I'm just going through it. Parking rates at the parking facilities at the hospital, how much they charge for parking, everything. Is that what we're looking? Is that what you're saying?
The petition would require that financial assets be made available.
But I'm just trying to understand the principle you're saying. Because this will raise costs, does that mean everything to do with the hospital, everything to do with how they raise money and spend money should be related and mutually dependent? Is that what you're saying?
I'm not saying that.
So what is the limitation you're imposing?
The limitation I'm imposing, well, first of all, I'm not suggesting that the two subjects are mutually dependent. What I'm suggesting is that they're related.
If they're not mutually dependent, you're not entitled to it.
They can be related without being mutually dependent.
They have to be related and mutually dependent.
The Article 48 is an or standard, and if subjects had to be mutually related, this court would have, I would suggest, have invalidated many petitions that it upheld as being consistent with Article 48.
Again, just back to my question, because I'm trying to understand, because your logic to me is that finances are related to paying for the cost, and there are no limitations on that, unless tell me what the limitation is so that I understand it.
The objective of the petition is to make transparent a hospital's available resources to pay for staffing at its
For those
hospital.
nurses, to pay for the cost of the extra nurses, you're
Yes.
entitled to all financial data.
The petition would require the hospital to disclose its assets that are available to provide these, if there's a need for additional nurse staffing, yes.
Well, no, but there is a need, so, so this may be an if, then why would you need it if it's not an if?
Certain I wasn't clear with my answer. Certain hospitals may not need to add staff to a particular unit or units. Other hospitals may need to add a lot of staff to a particular unit or units.
But I thought it's related, I thought you're entitled to every hospital's financial information because of that, but it sounds like it's more limited, what you're saying. I just don't understand what it is that's related.
Okay, it's related let me go back. In addition to certain hospitals perhaps not having to add staff to a unit or units, the petition has provisions in it which allow hospitals, either voluntarily or through patient acuity assessments or through collective bargaining, to reduce the limits.
You're trying to get access to financial data, huge amounts of financial data. And you're connecting that in an initiative petition. I just want to make sure I understand if there's any limitation on your relationship. I just don't see it. I thought your argument was very straightforward. This is going to increase costs for nurses, therefore the public can connect all hospital costs, but it sounds like you're qualifying that somehow.
I'm not qualifying it. If a hospital were required to add a nurse to a particular unit, it would cost additional money. My only further suggestion is that achieving the specified patient limits in the various sections of the petition is not the end of the petition's reach. The petition's reach suggests that the transparency provisions allowing the regulatory agency and the public to see the staffing limits. Particular hospitals could do far better in terms of staffing than the limits imposed by the specific limits set forth in the statute, the maximum limits. That provides a floor. Hospitals can do better if they so desire, or if there is a need based on patients.
That's not the issue before us, though. The issue before us is whether these two different provisions are related, right?
And I would suggest that that issue does relate to the question, because allowing the regulatory agency and the public to see what a particular hospital's assets are allows them to determine whether or not the staffing plans that they also have to file are not only compliant with the patient-nurse ratios, but whether they can do better. And if they're not compliant, why they're not compliant. Is it because of cost? Is it because they don't have the assets? Do they have the assets and they're choosing not to comply or not to supersede the limits that are contained within them? Cost and staffing together connect to care and safety of patients at hospitals. The limits imposed by the various sections is not a be-all and end-all of the petition. Having access to how hospitals not only staff, but what resources they have and choose to use to staff is the common purpose of this petition.
But why, I'm sorry. No, go ahead. I just had one last question. If you win, do you have two competing proposals and you've just knocked both of them out?
I thought of that question as I was sitting in the audience,
Yeah, okay.
listening to sex offender cases. There is provision, and perhaps my sister can clarify, but there is provision in Article 48, I believe, where the legislature can make decisions on how it wants to deal with either conflicting or alternative petitions. It is dealt with by the legislature. It could very well be dealt with
You're
by
going to
petitioners.
turn the initiative process over to the legislature. That's interesting.
It could be dealt with differently. It could be that the petitioners don't gain the requisite number of signatures before the first week in July. They would have to get an additional number of signatures.
Now, I'm no expert in accountancy, Lord knows, but generally ability to pay would be measured not simply by assets, but by assets as compared to liabilities. And there's no reference in the statute to liabilities, correct?
That's correct, Your Honor.
So a large hospital like Partners are going to, one would think, are going to have a lot of assets, and a community hospital are going to have very little assets. And if we don't know anything about their liabilities or their number of patients, how is that going to bear on their ability to pay for the registered nurse per patient or patient per registered nurse ratios?
The information that Your Honor is suggesting in terms of particularly cost and margins, let's say, is reported already to CHIA. And so the petition doesn't contain duplicative information that would be required to be filed by hospitals. CHIA has the data that would be needed to assess total revenues, to assess expenses, to assess margins, operating margins, and additional information that would allow one, conceivably, to make some assessment as to whether a particular hospital has additional revenue to pay for additional nursing staff. The issue that the specific issue that the petition adds is this requirement that the hospitals disclose, in addition to their revenues and expenses and margins, the available assets that it has and can apply to additional staffing, which currently, apparently there's a dispute, a legal dispute, as to whether CHIA can insist upon this information or not. That dispute would, we feel, be resolved in this section in the petition. Either way, more importantly to the issue at hand, is we feel that the overall picture of not only revenues and expenses and margins and available cash on hand might be used to add nursing staff, but that assets of a particular group, and the group contesting the CHIA requirements now happens to have roughly 30 hospitals outside of the Commonwealth of Massachusetts. Happens to be a for-profit hospital as well. Those issues of assets, and those aren't being disclosed to CHIA. The out-of-state financials of this particular hospital group with a fairly sizable presence in the Commonwealth, roughly 10 hospitals, doesn't currently feel it's obligated to disclose all of its financial information, particularly the financial information outside of Massachusetts. It doesn't disclose its parent organization's assets and the like, which we feel is part of the petition related to whether or not they would provide the amount of staff, all hospitals, including them, could provide the amount of staffing needed to make patients safe.
I have just a basic question that I should probably know the answer to, but 1708, is that just 1707 plus financial assets?
Yes. 1707 was certified by the Attorney General
Right, I understand.
and 1708 wasn't. The only difference between the two is the financial disclosure piece. That's
And
correct.
when it refers to nurses, do either petitions make a different distinction about kinds of nurses, LPNs or registered nurses, or?
The definition of nurses, I believe, refers to registered nurses.
Registered nurses, okay.
And just to be clear, you said it's an or standard, so are you focusing your argument on the relatedness portion as opposed to the mutually dependent part of Article 48?
Yes, Your Honor.
Okay.
All right, thank you.
Thank you.
Ms. Race?
Thank you, Your Honor. I'll start by answering Justice Kafker's question about the possibility of both petitions advancing to the ballot in November. If this court were to reverse the Attorney General's decision in this case and affirm it in the second case, it is possible, although I'd be surprised if the petitioners would choose to advance both of their questions, but it would be possible for both of them to appear on the ballot. The framers of Article 48 considered that possibility and made two provisions. One is that if both petitions, both proposed laws were to pass, and if a conflict between them were identified, which doesn't appear to me on its face, the highest vote getter would be deemed to be the prevailing law. Secondly, as my brother stated, the legislature may, but is not required to, take action to group the provisions together, proposals together as alternative proposals, and if it were to do so, the one that got the highest number of votes would be deemed to be the only one that was approved. But I'm not aware that either of those things has ever happened since 1918. On the point of whether the Section 231K of the proposed law, which would require asset disclosures, is intended to be nothing more than a supplement of the financial information currently gathered by the Center for Health Information and Analysis. I respectfully request that it is not. With respect to the first question on whether information about liability, income, revenue, the type of information that CHIA currently does collect, whether that would be part of 231K, I must correct what I think was a misstatement, that in fact it would be. 231K is limited by its terms to all financial assets owned by the facility, along with assets of any holding company and any and all parent, subsidiary, or affiliated companies, including those held in financial institutions outside the United States or invested outside the United States. So that relates only to financial assets. No information would be derived with respect to indebtedness, liabilities, other costs, or sources of revenue. Chapter 12C, Section 8, which is the statute authorizing the collection of this information by CHIA, has a statement of purpose in it. And that statement of purpose is not advancement of patient safety, except perhaps only in the most global and macro sense. The statement of purpose is that it is in the public's interest to be aware of the financial health of its acute care hospitals. In order to better protect the public's interest in monitoring the financial conditions of acute hospitals is stated in Section 8C of Chapter 12C. And the statute goes on to discuss what purpose CHIA is to put this information to, none of which would apply to the information gathered under Section 231K. CHIA is required to conduct analysis, present reports, publish annual reports, and specifically identify hospitals that CHIA considers to be in financial distress, including any hospitals at risk of closing or discontinuing essential health services. One could certainly say that at a broad macro level, such analysis and such work could be tied to patient safety, but the remainder of the petition at issue here works at a micro level. It works at a hospital patient level.
But isn't he making a sort of a, I mean, I may be misinterpreting his argument, but I thought he's saying simply, okay, this nursing staffing thing is going to, dramatically increase costs at hospitals, so, and the hospitals are going to say we can't afford it, therefore we're entitled to all the financial information, all the assets of the, and all income generating potential of the hospital. There's sort of a, simplicity to that, that I just want to make sure I understand why that's not related from your perspective.
Yes, Your Honor, and we probably would agree that it could be related if that information intersected in any way with the patient assignment limits, which it does not. There is no financial hardship defense for a facility's failure to comply. There is no provision for staging implementation based on financial health of hospitals. In fact, any delay in implementation of the patient assignment limits is specifically prohibited by the proposed law. And there's no provision for calculating penalties on the basis of financial hardship.
It's not narrowly tailored enough, or it's not, it's overly broad? I'm just trying to understand, because do our initiative cases do that kind of analysis?
The narrowly tailored analysis is not one that's been used, but certainly the court has looked at operationally how parts of the law work together. And in the Attorney General's view, Section 231K has both problems Your Honor's identified. One is it's too broad. It provides only for disclosure of assets and not other information that would be relevant on a hospital's ability to pay staffing costs, as the Chief Justice articulated. And secondly, even if the information that was going to be collected were more focused on the hospital's actual ability to pay staffing costs, there's no use to which that information would be put in implementing the patient assignment ratios.
They asked for the hospital's operating margins, or the stuff they put in their bond agreement, saying, look, this is how much cash we have on hand. Would that be operationally related?
As the petition stands, it would not. If there were something in the petition that would make that relevant.
Well, it's relevant because this petition is going to increase hospital costs substantially. So, and the defense is going to be, I'm not going to be able to pay for it.
There's
right?
no provision for a defense in the law, Your Honor. There's no provision at all.
Well, I know, but the public debate is going to be about how they pay for it, right?
But we have to look at whether the law as presented is operationally related. I certainly can see that as a matter of public debate, as a matter of political advocacy, or as a matter of collective bargaining, the drafters of this petition may well want to have that information. But as a matter of implementing this proposed law, there is no use to which that information can be put that would change in any way how the law would be implemented or how its violations would be enforced.
So you may have even intimated this, but you might well have a different view if the language involved financial data related or assets related to patient-nurse ratios or assignments.
Two things would have to happen for us to have a different view, Your Honor. One is, yes, that the information would have to be tied to the hospital's ability to pay staffing costs, but two, that there would be some window in the law to intersect that information with the patient assignment limits, which doesn't exist. If there were an exemption or it were a defense to a violation to claim financial hardship, then I would say yes, there would be an operational relationship and a reason that those that financial information you could choose.
So there's no exception.
Correct.
It's like this national health crisis exception issue.
Correct.
There's no exception. We just couldn't afford it.
Correct, Your Honor.
So if the provision had anything, if the other side of the initiative petition said, so long as the hospital can afford it, then you would be able to ask for all this information.
I think it would be a much closer question, and if the information that would have to be disclosed were calculated to answer the questions raised in the remainder of the petition, it would have been a much closer question on relatedness. We see this proposed law as very similar to the law that this court rejected in 2016 in Gray, where you had a change in substantive law in a particular area, which we don't take issue with, and this court didn't take issue with in Gray. In that case, it was a change of the academic standards to be used in public schools, and here it is a change in the establishment of patient-nurse limits outside of the ICU context. And, but then the petition in 2016 went on to include what this court called a transparency provision, and one could view Section 231K in the same light, and concluded that that transparency provision was a different public policy. And I would posit that the case in Gray was actually closer than this one, because the MCAS test items that would have had to be released under Section 4 of that proposed law would have provided at least some window into how and to what extent the new academic standards, or actually the revived academic standards, were being tested, because MCAS is designed to test students' knowledge of the academic standards. In this case, the financial asset requirement of 231K would not yield any information that would relate in any way to the establishment and implementation of the patient assignment limits. The petition presents these two distinct and dissimilar policy issues. I do agree with my brother that the related or mutually dependent language of Article 48 is disjunctive, and that a petition can be certified if it meets either of those criteria. There has not been very much discussion since 1918 in this court of mutually dependent. In fact, the first real substantive discussion was in the Gray case in 2016, but the court looked at that in the alternative and decided that the two subjects of that petition were neither related nor mutually dependent, and I would submit that the same exists here.
Might have been closer on mutually dependent, perhaps, publicizing all the information about the tests and whether that in any way was mutually dependent on the core curriculum.
True, and the court decided that because both parts of the law would operate in sort of a parallel sense, and neither would be applied any differently depending on the content of the other. For instance, what Justice Botsford wrote was that the MCAS disclosure requirement would apply regardless of which academic standards were being taught and tested. And the same applies here. The asset disclosure requirement would exist for all facilities, regardless of whether they were in compliance with the patient assignment limits, and they would be required to comply with the patient assignment limits, regardless of the content of their financial asset disclosures. So that is the same type of parallel process with no intersection that this court has previously rejected, and as I stated, I think this is easier in that sense than the proposal that was at issue in the Gray case. We certainly argued to this court that that the court should consider the MCAS disclosure requirement in Gray to be related, because it did provide or would provide a window into what academic standards were being tested. That argument was rejected, and here that window wouldn't exist at all.
Dissemination wouldn't do any good as it relates to the issue of evaluating patient-nurse ratios then.
Correct, Your Honor, because there is no provision for financial hardship.
Can I ask, I'm just looking, and I may be, the same language appears in, this sentence appears in both petitions, right? It is the responsibility of each facility to provide the resources necessary to support the safe patient limits. Does that appear in both petitions?
Both petitions are identical until you get to Section 231K.
Isn't that an operational connection? You've got to impose the nurse, the number of nurses, but you also have to be able to pay for it. So doesn't that create the connection you're talking about? Doesn't it have that sentence that that intersects the two?
I don't see that as an intersection, Your Honor, because it's almost self-evident that in order to provide more nurses, if that's what you have to do, and if you are not permitted to make certain other staff reductions, which is the subject of the next case, then you do need to commit more assets to that. But the public disclosure of what your assets aren't connected in any way to that.
when you get to, are you arguing the next case?
Yes,
too?
Your Honor.
Because I'm going to be asking you the exact same question. Why is that different? Why is the no layoff provision different than the provide us a breakdown of your resources provision? Because that also, the no layoff provision also has, you have to provide the staffing level regardless, right?
Yes, you do.
So I'm just trying to understand the difference between these two provisions from the AG's perspective, because you saw a difference. I just want to make sure I get what the difference is from your view.
We certainly did, and the difference is that the sort of point of intersection or the connection that we don't see in this provision, we do see in petition number 1707, and that is achieved through the word result. Section 231D, which is the section that is being challenged on its relatedness, requires that the patient assignment limits be implemented in such a way as they cannot result in staff layoff, and I'm certainly happy to address that more in the next case. But Your Honor is correct that what we are looking for is some kind of operational intersection, which is just absent here for the reasons I've stated. And the court has concluded that it is simply unfair to ask voters to vote on two distinct and dissimilar policy issues, which is what's presented by this petition. Thank you.
Thank you.